Hello everyone. Today we will gain some basic knowledge about the Constitution of India. It will be done through some multiple choice questions in which some valuable information will be shared with you. So without wasting any time, let's proceed to the questions.
The first question is, what is the date of adoption of Constitution? Options are A. 26 November 1949, B. 26 January 1950, C. 15th August 1947, and D. 30th January 1916. The correct answer to this question is 26th November 1949. On 26 November 1949, the Constituent Assembly adopted the Constitution of India, which was drafted by a committee which was headed by Dr. B.R. Ambedkar. The Constitution came into effect from 26 January 1950. Dr. B.R. Ambedkar is also known as the father of the Constitution of our nation.
So let's discuss about what is so special about this date. On 26 November 1949, the Constituent Assembly adopted the Constitution of India. The Constitution was drafted by the committee which was headed by Dr. B.R. Ambedkar. As per initials, his full name was Bhim Rao Ambedkar. The Constitution came into effect from 26 January 1950. Since then, 26 January is celebrated as the Republic Day. Bhim Rao Ambedkar was an Indian jurist, economist, politician, and a social reformer. He was the first Minister of Law and Justice of the independent India and was also the chief architect of the Constitution of India. That is why he is also known as Father of Indian Constitution.
The next question is, which country has the lengthiest constitution in the world? Options are A. United States, B. France, C. India, and D. Japan. The correct answer to this question is option C, that is India. The Constitution of India has around 444 articles that are divided into 22 parts and 12 schedules. India's constitution stands considerably larger than most of the constitution. The shortest constitution which is applicable in the world is of United States. It just contains 7 articles.
There are around 444 articles which are divided into 22 parts and 12 schedules in the Indian Constitution. Our Constitution is considered the largest and the lengthiest than any other constitution of the world. The Constitution of Monaco is the shortest written constitution, containing just 10 chapters with 97 articles and a total of 3,814 words. Although the Constitution of the United States is considered the world's oldest continuously active and codified constitution, which has enforced since 1789. Only half of the constitution functioned continuously for more than 19 years.
The next question is, which of the 3 words were added later to the preamble? Options are A. Justice, Liberty, Equality, B. Socialist, Republic, Justice, C. Sovereign, Fraternity, Political, D. Secular, Socialist, Integrity. The correct answer to this question is option D, that is Secular, Socialist, Integrity. Secular socialism into India were added through the 42nd Amendment Act in 1976.
These words were added through the 42nd Amendment Act in 1976. The 42nd Amendment was also the amendment in which the preamble was changed, and the description of the India was changed from sovereignty democratic republic to sovereign socialist secular democratic and republic nation. It was also changed the word unity of the nation to unity and the integrity of the nation. The 42nd Amendment to the Constitution of India was enacted during the emergency by the Indian National Congress government headed by Indira Gandhi. The provisions of the amendment came into effect on 3rd January 1977. So basically, the whole 42nd Amendment to the Constitution was done when the nation was going through a phase of emergency, which was headed by Indira Gandhi. In this amendment, the preamble was changed, and the three words that is sovereign, socialist, and secular was added to the existing preamble, and it was made a sovereign, socialist, secular, democratic, and a republic nation.
The next question is, which article in the Constitution provides guidelines for amending the preamble? Options are Article 30, B, Article 200, C, Article 368, and D, Article 256. Options are the answer to this question is option C, that is Article 368. Article 368 is a procedure for the amendment of Constitution, that how the Constitution should be amended without disturbing the basic structure of the Constitution. The Supreme Court, in various cases, has held that the Constitution is open for amendment, but the amendment should be done in a manner that it does not amend the basic structure or the basic purpose for which the Constitution was enacted in the initial years of the free India. And since the preamble is also regarded as a part of the Constitution, it can be amended. It was indeed amended in 1976 with the 42nd Amendment Act, in which three words were added.
Article 368 gives power to the Parliament to amend the Constitution. This article also lays the procedure on how to amend the Constitution. So let's discuss Article 368. Clause 1. Notwithstanding anything in this Constitution, Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this article. An amendment of this Constitution may be initiated only by introduction of a bill for a purpose in either House of the Parliament, and, and when the bill is passed in each House by a majority of total membership of that House present and voting, it shall be presented to the President, who shall give his assent to the bill, and thereupon the Constitution shall stand amended in accordance with the term of the bill. It is provided that a such amendment seeks to make any changes in Article 54, Article 55, Article 73, Article 162, or Article 241, or Chapter 4 of Part 5, Chapter 5 of Part 6, or Chapter 1 of Part 11, or any of the list in the 7th schedule or the representation of the states in the Parliament or the provision of this article, the amendment shall also require to be ratified by the legislature of not less than one half of the states, by resolution to that effect passed by those legislatures before the bill making the provision such amendment is presented to the President for assent.
Now let's move on to the next question. Which famous case involved the term basic structure of the Constitution? Options are A. Keshwananda Bharati vs. State of Kerala, B. Maneka Gandhi vs. Union of India, C. Vishaka vs. State of Rajasthan, and D. Indira Gandhi vs. Union of India. The correct answer to this question is option A, that is Keshwananda Bharati vs. State of Kerala. Keshwananda Bharati vs. State of Kerala is a landmark judgment in which the basic structure of the Constitution was discussed by the Supreme Court of India. It was said and dictated that the Constitution can be changed beyond a certain limit, and that the basic structure and the basic purpose should not be hampered by amending the Constitution. Which articles in the Constitution grant us the right to equality? Options are A. Article 14 to 18, B. Article 23 to 24, C. Article 32, and D. Article 368. The correct answer to the question is option A, that is Article 14 to 18. These articles includes the basic fundamental right that of equality before law, social equality, equal access to public area, equality in the matters of public employment, abolition of untouchability, and abolition of titles. These are the fundamental rights which can be exercised by every citizen of India, is bestowed upon them by the Constitution. And the very important article, or the very important right, is right to equality, which is given in Article 14, which says that every person is equal in front of law. Let's move on to the next question. Which articles in the Constitution grant us the right to freedom? Options are A. Article 14 to 18, B. Article 19 to 22, C. Article 32, and D. Article 368. The correct answer is Article 19 to 20, that is option B. The Article 19 to 22 gives us some basic right to freedom, like right freedom of speech and expression, freedom to assemble peacefully, freedom for association, freedom to move freely throughout the territory of India, freedom to live unsettled in any part of the territory, freedom to practice any profession or to carry on any occupation, trade, or business. But these rights are not absolute, as there are some restrictions or conditions that are imposed by the Constitution in various clauses of Article 19, which gives the restriction and the prohibition till the effective performance of these rights. Now let's move on to the next question. Which articles in the Constitution grant us the right against exploitation? Options are A. Article 14 to 18, B. Article 23 and 24, C. Article 32, D. Article 368. The correct answer to this question is B. Article 23 and 24. These articles stand for eradication of the human trafficking and forced labor, abolition of employment of children under the age of 14 years as dangerous jobs, mines, and etc. There was an amendment on right against exploitation, in which a new article was inserted by way of amendment. It was Article 21E, which stated that every person has a fundamental right to achieve education through various So the next question is, which article in the Constitution grants us the freedom of religion? Options are A. Article 14 to 18, B. Article 23 and 24, C. 25 to 28, and D. Article 368. The options are, the answer to this question is option C, that's Article 25 to 28. These articles is form part of the Constitution, stands for freedom of conscience and free profession, pattern propagation of religion, freedom to run religious affairs, no compulsion to pay any tax for the promotion or maintenance of any religion, freedom as to attendance to religious instructions or religious worship and certain educational instruction. The next question is, which article in the Constitution granted the right to constitutional remedies? Options are A. Article 14 to 18, B. Article 23 and 24, C. Article 32, and D. Article 368. The correct answer to this question is option C, that is Article 32. Article 32 is the right to the citizen of India to approach the court through various writs. Those five writs are the writ of habeas corpus, mandamus, prohibition, quo warranto, and search. So now let's see what these writs mean and how can they be used for ascertaining the right of a person in a country.
Article 32 provides us with various rights that are provided by the Constitution for the normal public. These rights aim at protecting the fundamental rights of the citizen. It gives the power to the citizen to ask questions to any public authority and to get a basic and a fair remedy against any violation or exploitation of the citizen of the country. Basically, there are five types of writs that the Constitution offers to its citizens. These are habeas corpus, mandamus, prohibition, quo warranto, and certiorari. So let's discuss each one in a brief manner. Starting with habeas corpus. Habeas corpus means that the arrested person must be brought before the court that holds the right to set a person free if the ground of arrest are not found to be faulty. It means that it gives the right to a person that the arrested person must be brought before the court so that he is heard by the court and the justice is given in his case. The next writ is mandamus. Mandamus basically is a Latin word which means we command. Mandamus is an order from the Supreme Court or the High Court to the lower court to perform a public or a statutory duty. This writ of command is issued by the Supreme Court or the High Court when any government, court, corporation, or any public authority has to do a public duty but fails to do so. So basically, mandamus is like a command by the Supreme Court and the High Court on every court, subordinate courts to do some work or to restrict from doing some work. The next writ is prohibition. The writ of prohibition means to forbid or to stop, and it is popularly known as stay order. This writ is issued when a lower court or a body tries to stress the limits on power vested in it. By using the writ prohibition, this upper court gives a stay order or prohibit the action of the lower court when it is seen that the lower court has trespassed or has extended its limit of jurisdiction or the quantum of punishment it can give. The next right is quo warranto. Quo warranto literally means by what warrants or what is your authority. It is a writ issued with a view to restrain a person from holding a public office to which he is not entitled. This writ is helpful in asking a question to a public authority or a public officer: by what authority do you hold this position? And this, the public officer is on the duty, has the duty to prove that he is ought to have been entitled to that office or that position. The next and the last writ is certiorari. Certiorari literally means to be certified. The writ of certiorari can be issued by Supreme Court or any High Court for quashing the order already passed by an inferior court, tribunal, or a quasi-judicial authority.
The next question is the feature of the concurrent list of constitutions borrowed from which country's constitution? Options are A. Japan, B. Ireland, C. United States, and D. Australia. The correct answer to this question is option D, that is Australia. The next question is which constitutional amendment added the part of the fundamental duties to the Constitution? Options are A. 47th Constitutional Amendment, B. Constitutional Amendment, C. 78th Constitutional Amendment, or D. 34th Constitutional Amendment. The correct answer to this question is option A, that is 42nd Constitutional Amendment. These amendments were added by the recommendation of Swaranson Committee. The next question is the Westminster model of government followed by India is borrowed from. Options are British form of government, B. United States, C. Japanese form of government, or D. Australian form of government. The correct answer to this question is British form of government. Trivia: the UK also has an unwritten constitution, meaning it doesn't have any single document that prohibits all of the principles and laws. UK believes in giving consent to people, and that is why they don't have any written constitution. It is in consent of the people of the UK to follow the general norms of society. The next question is the parliamentary form of government is borrowed from which form of government? Options are E. British form of government, B. United States, C. Japanese form of government, or D. Australian form of government. The correct answer to this question is option A, that is British form of government. The next question is the idea of the Fundamental Rights and Judicial review is borrowed from which of the following government? A. British form of government, B. United States, C. Japanese form of government, or D. Australian form of government. The correct answer to this question is the government of the United States of America. That is option B. The next question is the idea of the direct principle of the state policy is borrowed from A. Ireland, B. United States, C. British government, or D. Canada. The answer to this question is option A, that is Ireland. The idea of the DPS was adopted from the Irish Constitution. Although DPS cannot be imposed as a right States can take certain measures to see whether DPSPs are followed or are enacted in the current society or in the current situation in India. These state policies cannot be harshly imposed on every person, but the state has the choice whether to impose it or not. These principles are based on which the state is supposed to act. A constitutional amendment bill is necessary to bring about a change in directory principles. Now let's move on to the next question. The concept of suspension of fundamental rights during emergency is taken in which form of government? Options are A. The Weimar Constitution of Germany, B. United States, C. Japan, and D. Australia. The correct answer to this question is A. The Weimar Constitution of Germany. Talking about emergency, there are three types of emergency: financial emergency, national emergency, and referency. There are basically three incidents when emergency was declared in India. First was Indochina War, second Indo-Pak War, and third was the Indo-Iranian threat to the national security due to internal disturbance. The next question is, the idea of liberty, equality, and fraternity are taken from the following countries. Options are E. United States, B. Spain, C. Greece, and D. France. The correct answer to this question is option D, that is France. Liberty, equality, and fraternity serves as the national motto of France and Republic of Haiti. The motto was first used in the French Revolution. Next question is, which schedule contains the provisions relating to the administration and control of scheduled areas and scheduled tribes? Options are fourth schedule, B. Fifth schedule, C. Sixth schedule, and D. Seventh schedule. The correct answer to this question is fifth schedule. The next question is, which schedule in the Indian Constitution specifies the power, authority, and responsibility of panchayats? Options are fourth schedule, B. Sixth schedule, C. Seventh schedule, or D. 11th schedule. Correct answer to this question is option D. 11th schedule.